is data exchange. How do we handle data when it crosses borders? Of course, on the one hand, it's about data that crosses European borders between the states of the European Union, but it goes beyond that. What are the security and privacy issues that we need to deal with? And so I think the event today is particularly timely to discuss cross-border data flows, security and privacy within the EU and beyond. We are very pleased also to have an excellent keynote speaker and a very good panel at the same time. And I'm looking forward to an excellent evening tonight. And with that, I would like to hand over to our very experienced moderator, David Goodman, to take you through the rest of the evening. David.
Thank you, Amadeo. And without further ado, I'd like to introduce the panel. But first, the panel, we're very fortunate to have Wojciech Wiewiorowski, who is European Data Protection Supervisor, Cornelia Kutera from Microsoft. Unfortunately, Jörg Hlajic is not to join us today before a personal emergency. And we wish him well, but we are fortunate to have Laurent de Mute, I probably mispronounced your name, I do apologize, to join us from JonesDay instead. And finally, but last but not least, Romain Robert, and I hope I pronounced your name correctly, Romain. Yeah, excellent. And he is the program director from NYOB. And for those of you who are not familiar with NYOB, that is none of your business. I'm sure that is an excellent joke that is played many times. So to kick us off, we asked Wojciech to give us an introduction, a keynote introduction. So I would like to hand over to you, Wojciech, to give us your thoughts on cross-border data flows. I should say that the context of this, for those of you who have not followed the discussion, is very much about Schrems II, the European Court of Justice rulings last July, which had significant repercussions on cross-border transfers, particularly with third countries. My apologies, Wojciech. Over to you.
Thank you very much. Do you think it will be possible for me to upload the presentation with me, help us to get through the whole idea?
Yeah, I've just made you presenter, so you should be able to share your screen and just share the application.
Okay, I'm checking fast.
That will be at the bottom of the screen.
Trying to find the right button for that. Okay, now starting EDPS. Now starting EDPS. I will start it in the other window. Okay.
Did you find it okay?
Yes. Just a while. It will go on in a second. I'm just trying to put the right window on, but it's not the right one. It's not exactly the one which I wanted to show, but
Are you having a problem, Wojciech?
yes, but the problem is only caused by my own computer, so I guess I will simply start without the presentation, and it will be.
You can, if you want to send it to me, I can load it for you.
Starting the wrong window. The last attempt.
It was all going so well.
Okay, I will start.
You're on mute now, Wojciech.
Okay, no.
Okay.
No, I think it will go. I will resign from the presentation. For some reason, it doesn't want to show the right window on my computer. But actually, what I wanted to do today, I wanted to go to take you through the whole line of events, the line of things which happened last year, as far as transfer to third countries is concerned. That will be a short hitchhiking for those who are familiar with data protection issues and who followed that, but it will remind also where are we. We have to remember that the 2020 for the data protection will not be only the time of COVID, will not be only the time of special, extraordinary circumstances which we found for the whole data protection issues in the European Union because of the pandemic, but that will also be the time when we started to make the kind of check of how the GDPR works in practice. And it could be started because of the work of the data protection authorities, but also because of the civic society and the actions which have been started by the line of the data protection organizations, the consumer organizations, and the NGOs which try to check all the possible remedies which have been prepared in the GDPR. European Data Protection Supervisor, as the supervisor of the EU institutions, bodies and agencies, tried to implement at the same time the solutions coming from the regulation 2018-7025, which is sometimes called the GDPR for the EU institutions, bodies and agencies. So we were one of the enforcement authorities, one of those who had to take on themselves the special amount of the decisions to be taken, special amounts of complaints to be solved. but also, which I think is the most important and the most challenging, all the expectations that we had from 2012, when the data protection reform has started. And this process have been accelerated by the decision from the data protection from the Court of Justice of the European Union in the case which is called Schrems 2. For most of you, these are the very well-known happenings, very well-known points in the history of data protection. But let me look at this from a little bit personal perspective as the Data Protection Authority, which looked at the trans-border data flows and the doubts which we had over the trans-border data flows from 2010, when I started to work as the Polish Data Protection Commissioner. I have to say that the whole story of Max Schrems' cases, starting with his organization Europe versus Facebook, through 2015 judgment and the judgment from 2020, is a kind of yellow light, which shows that being a student and asking if the things which he learned in the university are really right gives you as much power as is necessary to move the stones which the data protection authorities were not able to move for 15 years. And I have to say, being the DPA in this time, that actually the questions which were asked by Max in the case which was finished in 2015, but also in the one in 2020, these are the questions that the data protection authorities should ask. And we haven't learned that much the lesson which have been taught to us by the Court of Justice in 2015 when Schrems 1 judgment happened. I have to take some responsibility for the fact that while the Privacy Shield the decision has been annulled by the Court of Justice in 2020, we have made the assessment of the enforcement of the same Privacy Shield decision just a year before. And as the member of the European Data Protection Board, with all the doubts we had, with all the questions which we issued, we actually found it still possible to be the main base of the transfers to the United States, and then we were stopped by the court. As you know, nobody was really surprised by the decision about the Privacy Shield, but once again, I have to say that even the data protection authorities were surprised by the decision on standard contractual clauses. Not the fact that the standard contractual clauses themselves have stayed in the acquis, but the fact that the court has decided to go that deep in quite theoretical discussion on what should be the test, what should be the way to assess the tools which are in use in the European Union. So with all this self-criticism to the approach that the data protection authorities had in these years, we have to also say that the work which have been done to solve and to go through the complaints, to solve the cases which landed in the data protection authorities was really enormous, and shown most of the possible angles from which the data subjects can be concerned by the way their data is used. I said about this the surprises that we had when the judgments came, but on the other hand, some of the things which surprised the Data Protection Society and also the representatives of the business after this case were quite surprising, were quite, I may say, unsurprising for those who really know what the data protection law was all about. I especially mean the problem of assessment of the situation in the third countries, which have been assigned, I would say assigned by the Court of Justice to the controllers. That has been always the principle of the data protection law in Europe, that this is the controller who is responsible for that. It didn't even start in 1995 with the directive from the EU. It actually started at least in the Convention 108 of the Council of Europe. So this part should not be that surprising for us. Moreover, this is not surprising also if we think about the other sectors, the other legal solutions in the European Union, which all go to the general principle that if you want to do something out of the zone which the EU is recognizing as the trust zone, the zone of the European Union or European Economic Area, you have to present the knowledge on where you are sending your money, your assets, your data, your people. So this part of the judgment was not that surprising. And then let me go to the 3 short points of the proposals how to solve the problem, how to solve the temporary, probably temporary, lack of the tools which we can use easily for the for transfer, but also for the remedies in case the harms to the data subjects are done. The first one is the list of so-called supplementary measures that should supplement the tools which are in hand of the controllers. And we have been prepared by the European Data Protection Board because of the expectations that were directed to the board, which have been then given for the public consultation. And finally, in the, let's say, Anno Domini 2021 version adopted a few weeks ago. The second thing, which are the standard contractual clauses offered by the Commission, and third, the enforcement actions and coordinated enforcement actions which are right now going on from the data protection authorities. If we think about supplementary measures, the whole philosophy that was proposed by the European Data Protection Board was that there will be no list of the supplementary measures or no checkpoints, no checklists, no templates offered, because that was something which would be understood as over-regulation. But there should be rather the methodology of dealing with the problem which the data protection authorities should propose. And this methodology starts with the 6 steps. Know your transfer, identify transfer tools, assess whether the transfer tools are effective, adopt supplementary measures, implement, and re-evaluate again on the regular intervals. And as you know, the discussion from when the supplementary measures were proposed by the EDPB was quite a long one, and there were more than 200 documents which were delivered to the European Data Protection Board. There were many suggestions in the relations to so-called risk-based approach, whatever it would mean, whether the data exporters could complete their analysis of the letter of the legislation in the third countries with the analysis or the implementations in practice. And there were some modifications. One of the main modifications which happened was unsurprisingly related to the importance of the examining of the practices of the third country public authorities in the exporters' legal assessment. The new version of the recommendation emphasizes the importance of the examining of the practices of the third country authorities to determine whether the legislation or the practices of the third country impinge in practice the effectiveness of the transfer tools used. To this end, the objective of the publicly available information from the case law, parliaments, oversight bodies, NGOs, and practical experiences of the importers and other entities in similar situation could be really considered together to determine the application of this problematic legislation. It's important also to note that the experience of the individual importers, including their lack of prior receipt of requests from the public authorities of the third countries, could never be sufficient by itself to justify proceeding with transfer that falls within the scope of this legislation. And the EDPDB has provided the limitations and criteria needed to be set to determine what could qualify as sufficient objective reliable elements in the exporters and importers assessment of these elements, and which of them should be documented. And using this assessment and this philosophy that was proposed by the European Data Protection Board, also the European Data Protection Supervisor started the second phase of the enforcement procedures after the Schrems II judgments. We first mapped the situation which is going on in the European Union institutions with the data transfers. We tried to find which tools are in use, and now we started the first line of the actions which are connected with the transfers themselves. And one of these actions is the investigation, or rather investigations regarding the use of the cloud services provided by Amazon and by Microsoft Web Services under the so-called Cloud 2 contract to the European Union institutions. And that is at the moment the main field of interest for us in the practical answers to the questions which are being given by the court in the Schrems II judgment. What is interesting is that by these investigations, we are checking what is the willingness of those who passed this legislation, Council and the Parliament, those who drafted it, Commission, and those who judged in this Schrems II judgment, so the Court of Justice, to use it for their own transfers to the third countries. Sorry for this long introduction and for the technical problems at the beginning. I'm happy to take part in the discussion, but first of all, to hear the position of both the representatives of the business and those who, as I said, had the pivotal role in starting the whole process, means NGOs, especially not of EU business.
Thank you very much, Wojciech, for that comprehensive introduction to the subject matter and the complete transparency and honest statements that you made, certainly earlier on. I was intrigued by your suggestion that almost that without Max Schrems, the things that he discovered, you suggested as a student, basic things that he learned at university enabled him to challenge the might of some of the tech giants. I think you said he was able to move stones that the DPAs couldn't do themselves. So I was wondering if Max Schrems...
I would even say we're not brave enough to do so.
Right. That's really that's a great statement. So I guess one of the questions was, if Max Schrems had not been interested in privacy, what would have changed over the last 6 years if Schrems 1, Schrems 2 hadn't happened due to Max's intervention? Would anything have happened, or would we have just bumbled on as we were? I think you're on mute.
Is it the question to me?
Yeah.
Well, I don't know. I hope that I would hope to answer no. Of course, it would happen anyway, because the situation was enough fired, I may say. I mean, the fire was just over the doors. But on the other hand, as I said, what happened just before the Schrems 2 judgment, which is the evaluation of the privacy shield done in 2019, shows that most probably the regulators were not ready to challenge the whole system, and also the number of the questions which were issued before and the actions which were started by the citizens was too small. Well, I reminded myself the Snowden revelations, which were surprising for everybody in the world except the data protection authorities and those people who were taking part in the CPTP conference, because there were the lectures of, I remember the lecture of Casper Bowden on the subject in 2012, so a year before Snowden. But of course, he didn't have the evidences. He didn't have the. He didn't know how it works in practice. But he was talking about the legal revelations which have been revealed in 2013. So I cannot say that we were not aware of that.
Interesting, very interesting. There are a lot of points that you raised that I think will come up later on in the discussion. But I'd like to turn now to Cornelia Kutera from Microsoft. Microsoft's name has been mentioned already, but it would be interesting, obviously, to hear from an industrial organization, one that's a multinational based in the United States, obviously. Your take on Schrems 2 and the current state of affairs from your perspective.
Yes, thanks, David. And let me say a couple of words before I go into the substance. First, it's a really great pleasure to be at a conference or panel discussion of Trust in Digital Life. I've been very fond of TDL. And when it started, I lost a little bit sight, but so glad to be back here. And Wojciech, absolutely, I do recall the lecture of Casper. And Casper obviously was also a colleague of mine for quite some time. And maybe we can even go a little bit more back in history than the lecture of Casper and the year later, the Snowden revelation. I think with 9/11, a lot has changed, and the measures that had been taken at that time, specifically in the United States. And so I think that is really the time frame in which we are working. But let me also just give a little bit of an economic perspective on this, and in particular, in the context also of what we have seen over the last year in confinement and how the world has really changed. So I think now there's no way around it. Data-driven innovation is basically the foundation of economic growth and social well-being. Having myself 3 kids in school and having endured confinement at home, having them move to the cloud was really very helpful. So we have seen also a lot of innovation around this. There's really this foundation of data, information, knowledge, and wisdom that is underlying in this context innovation. Then the economic impact of a fragmented data layer is significant, and we have seen there is a data transfers are estimated to contribute $2.8 trillion to the global GDP. And that goes now through all technology segments and industries. This is no longer only a tech issue, it is really the whole industry that is impacted and requires data transfers. In a recent survey conducted, over 90% of EU-based companies from all sectors do transfer data outside of the EU, and often in multiple countries, and that these transfers are predominantly used for business-to-business purposes. So there's really this is the economic context here is, I think, very significant. And there's a social impact of disrupting cross-border data flows. We have seen this in particular in the context of COVID, but in particular also in the research on healthcare. And we have seen significant impact since 2018. For example, 40 health research projects, investigation, diseases from cancer to Alzheimer have been suspended as a result of certain restrictions. And the impact over the last couple of months in some transfers being suspended have also made some of the headlines. So this is, I think, really important context to the overall discussion. With this said, we have significantly worked on this, and maybe just to give you a couple of ideas in how we have responded to the judgment, as you mentioned. First of all, Microsoft has been involved in the discussions after the safe harbor adequacy decision has been overruled by the European Court of Justice. We have been trying to help with commitments in the context of the Privacy Shield. We were interveners in the Privacy Shield proceeding, which was then obviously obsolete by the judgment, the Schrems II judgment. So this has, in the Privacy Shield, this has affected over 5,000 companies, including Microsoft. And we have for many years provided customers with overlapping protections under both the standard contractual clauses and the EU-US Privacy Shield legal framework. So as a Microsoft response to the Privacy Shield, we have announced to amend our online service data protection addendum in the light of that decision, and moved basically those services, extending them under the use of the standard contractual clauses as a lawful basis for data transfers. We have then also responded after the publication of the draft recommendations in November with new protections that we have announced to including contractual commitments in relation to government requests, for example. But we've also had, of course, additional steps that we call the new steps to defend your data commitments that we have made public, that basically added to the already existing commitments under our privacy principles. We have been discussing, is actually for many years contributed to the discussions that the European Commission held on the standard contractual clauses, and have been quite pleased to see them adopting those. We expect of course now the additional guidance from the Commission, and we are quite quite pleased to see that there will be an ongoing dialogue around the standard contractual clauses. They are more adapted to how data is transferred. The older standard contractual clauses were obviously fairly old. So that is all quite positive. We were also positively pleased and have encouraged on the US side, the US government, to continue and speed up the conversations with the European Commission on a new privacy shield, whatever the name will be, once that is happening. And we will continue to press in the United States for a speedy negotiations with the European Parliament. We believe that the recommendations of the European Data Protection Board are helpful, and we are currently, while implementing the new standard contractual clauses, using the guidance and the recommendations to adopt further those measures that we had already taken back in November. Then, of course, there is additional points that I could raise, such as the important discussions that have taken place over the last couple of months at the OECD on forming a better understanding on government access to data. Those hopefully will come to at least to a partial conclusion very soon. And this will be certainly very, very helpful in the context of negotiations between the US and the EU. But of course, just to say and underline again, and Wojciech has mentioned that this might be temporary lack of additional tools. That certainly only goes for those countries that have a negotiation ongoing with the European Commission on adequacy, not necessarily for many others where this is not the case. So many businesses will continuously have to rely on the standard contractual clauses and the supplementary measures. I'll stop here. There's obviously much more to say, but want to give the other panelists enough time as well.
Well, thank you, Cornelia. Just for those who are not familiar with the intricacies of what Cornelia was saying, the standard contractual clauses, the SCCs, have been around for a long time, I think, since Wojciech mentioned. And two new sets of SCCs were adopted by the European Commission at the beginning of June. So this is very fresh. And industry and lawyers and the world at large are coming to grips with what they mean, how to implement them, and how to make the transition from the old SCCs and the Privacy Shield itself to the new set of recommendations and regulations. So you mentioned the United States working closely with Brussels. President Biden was visibly in Brussels at the beginning of June, I think, or sometime in June. And I know that the Privacy Shield discussions were hot there. Do you have any inclination or have any influence on the Department of Commerce in the United States in terms, because I believe they're the ones responsible for drafting a new Privacy Shield, what their position is and what kind of time frame we might realistically envisage for a new Privacy Shield to be drafted and adopted?
Yeah, that's a hard question. So industry more generally is in discussions and dialogue with the US administration, and that includes not only the Department of Commerce, but also the State Department, the White House, the ODNI. And all of them are very focused in finding solutions and addressing the shortcomings that are pointed out or pointed to in the Schrems II discussions, and finding ways to accommodate concerns in a way that is feasible under the US legal frameworks. That is obviously a very complicated issue. I will say so that since there is over the last year or so, and I think rightly so, there has been much more focus on the security element of the decision, obviously as an effect of the Schrems II decision. Some of those discussions that are taking place now and what type of tools or what type of additional measures can be taken actually took place under the first Privacy Shield discussions as well. They were just not taken on board. So I think there is room to accommodate those, but now I'm not a US lawyer. Maybe Laurent has a little bit more insights into these aspects. But I think it's currently more a question of how those negotiations going, and those negotiations also have a lot to do with the personnel and the trust they have been building up. So the meeting, I think, or the visit of the US administration, including, by the way, the key negotiators of a potential new Privacy Shield, has been a really important sign. Also, a really important sign to the industry and the trust that solutions can be found. I think that is very important to install that as well. I think that the areas that need to be solved are fairly clear, including the situation with the ombudsman and redress. We all know that, and there is very smart academics on both sides of the Atlantic that have discussed publicly and with the US and with the EU potential solutions. So at least from where I stand, I do believe that this is feasible, and I would hope that it doesn't take too long.
Good. Well, that's what we want to hear, obviously. But some of what you said there forms a neat segue into our next panelist, Laurent Demoutier, who is from JonesDay. JonesDay is a US legal company, but they also have offices in Europe. And Laurent, as Jörg Lagic, is based in Brussels, I believe. This is I would imagine, and we look forward to hearing from you, that the issues associated with dealing with the potential economic disruption that Cornelia mentioned, and the various transition periods associated with implementing the new SECs, and the periods in which companies are allowed to use the old arrangements that they have, must be a complete nightmare for many companies. And I'm sure that they turn to their lawyers to help them out. So we look forward to hearing your perspective on the impact of the Schrems II ruling, and particularly the statements about the Privacy Shield that it was said does not provide adequate protections to EU citizens on government snooping. A small statement with significant repercussions. So, Laurent.
Yes, thank you, David. Indeed, I'd like to speak a little bit of the practical implication of the new SECs and the recommendations for clients. I mean, we are all in the process of analyzing them, implementing them for clients. It's indeed not always useful, but because before moving to kind of the good or bad points or the difficulties with the new SECs and the recommendation, let me just make a contextual point on Schrems II, which has created, I mean, it's since Schrems I and Schrems II have created a lot of regulatory uncertainties for companies. And to some extent, I think, I mean, as you know, I'm doing data protection, but I'm also doing telecom regulation and so on. And I think you cannot look at Schrems 1 and Schrems 2 without looking also at the position that the court has taken in terms of telecom metadata and the law enforcement in the EU to metadata, where the court has taken a series since the data retention directive has been annulled. The court has taken a series of very strong judgments limiting the ability of law enforcement authorities to access data. And I think to some extent that influenced probably kind of the very strict approach in Schrems and the annulment of the safe harbor and then afterwards the privacy shield, to the extent that you probably don't want to have a situation where European law enforcement authorities do not have access to data which is accessible to law enforcement authorities elsewhere. So I think that's to some extent that is a conceptual argument which I think is you should also consider when you're looking at the Schrems 1 and 2 decision. Now, if we look at SEC, because I think that the fact is that SEC is a very important, practically it's the most important element for transferring data. It's more the most important safeguards, most widely used. BCRs can in some case be useful, but they take time. A lot of time, especially now that more and more companies try to rely on them. So they can be, for example, for intra-group transfer, a useful tool, but it is a complex one, and it's not, I mean, you have to wait certainly several years before you can actually rely on them. And then if you take all the derogation, like consent and so on, I mean, that only works for very specific data transfer and not for regular data transfer. So SEC is really the standard. And so that's why in Schrems 2 it was important that it was withheld as a standard for transferring data. And it's, of course, welcome now that we have new SECs since about a month. And this provides legal certainty for the business. Certainly it puts the new SECs in line with the GDPR, which is a good thing, and also in line with the Schrems 2 decision. So that's really the good point. The good point is also that it's quite flexible. I think, I mean, it looks at the various situation, tries to cover all situation, control, transfer from controller to controller, control to processor, processor to processor. So it really tries to have a modular and flexible approach. So I think that's useful. It also covers and clarifies some situations which were not previously clarified. So, for example, the situation of a company located outside the EU, but that is covered by the GDPR because it's providing services in the EU under 3.2. You have to comply with GDPR. Now it makes the new SECs make clear that when such a company exports data, it can also rely on SECs. There remains for me one uncertainty, which relates to the actual access to the data by such company which is located outside the EU, which has to respect the GDPR. So it is subject to the GDPR. The question does, in terms of the transfer, does it need to also implement, for example, the supplementary measure? I mean, that's a question maybe Wojciech can clarify later on. But for me, that's still something that is a bit uncertain. I think another very welcome provision is the docking clause. Because previously, especially for intra-group data transfer, you used to have kind of framework agreement to which you would have all subsidiaries signed and then have the standard contractual clause as an annex. No, you don't need that. You have the docking clause, so you can have new companies accessing. So you have a multi-party SECs. So that's very useful. There again, maybe a question for the debate is. You know that you need also to have to implement measures in relation to onward transfer. So when you have a transfer to a new, for example, a US company which is transferring to a sub-processor in the US, then the question is, what do you do? Do you need to use that docking clause? Do you just make them sign the SECs? Do you need to sign new new SCCs, I mean, it's also one of the particular difficulties you can find. The new SCCs also provide a list of obligations for the importers. So the importers will have a series of obligations towards not only the data exporters, but also data subject directly, or the DPA. So there are, I mean, clearly there are a list of obligations for data importers. So it is a lot of work to implement for importers as well. And then now, if we look at more the more complex or difficult point, I mean, clearly, and that's not necessarily the fault of the Commission. That to some extent stems from the Schrems too, but it is a bit it is complex and more complex to implement. You know, you have to do this data transfer impact assessment, which is something you have to do now even for BCRs. I mean, clearly, for small businesses, and I'm speaking of companies, global companies, for example, which only need intragroup data transfer for the employees' data. I mean, it's which are active in a lot of countries. Making such assessments to a list of potentially very significant numbers of countries is a complex exercise. And the privacy shield in that regard, for example, is a much more easy way for small companies to just comply with that want to comply, but just want to a more easy process. Then, with regard to the supplementary measures, so you need to conduct this data transfer impact assessment, and then if you came to the conclusion that you need that the protection is sufficient, you need to implement supplementary measures. I mean, that maybe two remarks. I mean, Wojciech mentioned that there's no list. Indeed, there are lists of example in Annex 2 of the recommendation of the board. Of course, those are only example, so they don't cover all situation. That's on purpose, but that also means that it leaves a real burden on companies to make sure that they implement the appropriate measures. And so, I mean, we spoke earlier on of the various steps, including enforcement. I would expect that there is some flexibility in the enforcement with regard to what is an appropriate measures in view of the lack of a complete list of certainty with regard to what is an appropriate measures and what is not. Another point, which is the main change, as we mentioned previously, between the previous version of the recommendation and the new version, is that the new version concentrates on also takes into account the practice of which is applicable in member states. And Wojciech mentioned it is not sufficient that you didn't get, for example, any requests in the last years, because you can be a new entrant and can be your own experience may not reflect what the practice is. But then again, I mean, what are the questions you can ask from an importers in terms of knowing all the practice in a sector? I mean, it knows what happens to him. It doesn't know what happens to its competitors. And so the exercise might not always be easy with regard to that practice. I'm not saying it's a bad thing, because I think to some extent the fact that, for example, you take into account the practice also to disregard sometimes laws that are not applied in practice is a good thing. But the fact that you have to take sometimes into account practice, governmental practice that you may not be aware of, may be more complex. Finally, as we say, I think there is a lot of process and documentation that needs to be implemented by importers on various aspects, data breach and so on. So there's a lot of internal process that the SECs requires now from an importers. To some extent, that puts them in line with GDPR, but it is indeed a significant amount of work for companies. And then the question that remains maybe open with regard to all those tasks and process and obligation is the liability question. So there are some liability questions in a provision in the SCCs, but those are generally relatively broad. And so the question is to what extent you can still allocate liability, at least between the importers and the exporters, in a way that remains compatible with the SCCs, because of course you can only add provision but not have any provision that would contradict the SCCs. So I mean, in a nutshell, that's a bit the good points, the bad points I wanted to raise. I think it's generally it's a welcome development. The new SCCs, it's reduced the legal uncertainty around created by the Schrems II. But it's increased significantly the work of companies and of their lawyers in terms of making sure that they are properly implemented.
Thank you, Laurent. There are a number of points there that maybe Wojciech and some of the others might wish to respond to in a moment, that we can follow up on. But I'd like to bring in Romain Robert, and I think you could start by, I think people on the panel know where you're from, but for those who don't, they've heard the name Schrems, Max Schrems mentioned numerous times this evening already. And I think it would be good to just give a brief introduction to NYOB, and also your take on, and your company's take on where we are, how we've progressed over the last 12 months since the judgment was made by the European Court of Justice, and where you see us going in the future. That would also be very useful. So, Romain, to you.
Thank you, David. Do you hear me?
Yeah, we hear you.
Yeah. Thank you for the invitation and for the occasion to share some views on the SCC and the transfer. So for the ones who never heard about NYOB, so it's a very difficult way to pronounce, so it's not maybe the best name for an NGO. NYOB stands for None of Your Business, and I think it's like, as you said, a nice joke, but it's also the name of the organization, an NGO, non-profit organization founded by Max Schrems 3 years ago. NYOB is a small NGO of 15 persons. We are just actually 8 lawyers, and I see Max passing by, so it's not really far. We are working since 3 years to implement and defend the privacy right and data protection right of individuals in the EU, meaning we just filing complaints and file litigation. We do basically what is called strategic litigation in the EU. So we don't do lobby or advocacy, but we just focus on litigation and enforcement, especially of the GDPR. And we are based in Vienna, which is a lovely city. So that's a little bit the history of NYOB so far. And of course, the history of NYOB is, of course, for this reason, deeply linked to Max Schrems, who has actually a decision of the Court of Justice in this name. So we follow quite closely the case of transfer and everything which is around transfer, and especially, of course, the last decision of the Court of Justice in Schrems II, but also the SCCs and the EDPS guidelines. And in this respect, I'm happy to share a few first views maybe on the new SCCs and the Schrems transfer. First of all, I hear, and I think it was you, Cornelia, that since 2018, we witnessed a lot of impacted businesses and suspension of transfer, and I'm quite surprised to hear it, because I really don't understand why the companies just waited for a second case of the Court of Justice in 2020 to understand what the Court of Justice already said the first time in 2015, that the transfer to the US were lacking 2 fundamental elements. The first one was the massive collection of transfer of data coming from the EU and the lack of judicial redress. Actually, and I'm sure we could agree that the privacy expert and data protection expert were not really learning a lot of new things with this July decision of last year. The court basically just reaffirmed what he already said like 5 years before. So when I hear that it came like a surprise, I'm still surprised myself to hear that the companies and the industry were not really prepared and had to suspend transfer that were already illegal under the first decision of the court in Schrems 1 and under the former directive. So maybe it's also interesting to see what was new for these companies, and I don't see there was not a challenge for SCORE, of course, and I don't deny that after Schrems 2 there was a lot of new challenges that were popping up into place, especially the additional measures and in USCC. That is not something that I could dispute, but I think the novelty of the problematic transfer is not in Schrems 2. It's basically already there with the Schrems 1 decision in October 2015. Regarding the progress, because we also, of course, follow a little bit the progress of what could happen in the US, we personally think that, and that's also a personal view, that whatever you want to call this new deal between the EU and the US, let's call it a privacy trampoline or data protection umbrella, I'm not sure that the name is going to be of big importance. It will not fly if the two big elements that were pointed out by the court, meaning the massive collection and the lack of judicial redress for the EU citizen, will not be addressed by this deal. So we can try to go for a third agreement between the EU and the US, but if these problems that are not addressed now by the US administrations are still not addressed in the future, I think we can agree that we're going to go for Schrems 3. And I think we all would like to avoid a Schrems 3 decision at the Court of Justice. And I would be the first one to avoid one, trust me, and Max as well. So I think we would just like to avoid to have uncertainties for sure, but we also have to go for sound reasoning and sound legal element that we have to take into account for a new potential deal between the US and the EU. Another thing that I wanted to share maybe is the experience that we have since Schrems 2, because I understand, and I think it's also interesting to discuss what is the experience of the companies and especially the SMEs after the Schrems 1 and Schrems 2. I understand that there was a lot of disruption in the businesses and a lot of potential suspension of transfer. But so far, I would like to remind, and since the Schrems 2 decision in July, we only witnessed one decision of a DPA suspending the transfer in the EU. So in terms of enforcement of Schrems 1 and Schrems 2, I must say that I'm a little bit, I'm not really well confident about the enforcement of this Schrems 2 and Schrems 2 decision. It's quite difficult to get a decision for the enforcement of these two rulings. And to be even more concrete with some examples, as you may know, we launched a series of complaints in last August, called the 101 complaint. It was just for fun. We just ended up with 101 complaint, 101 complaint, and we called them the Dalmatians complaint. But it's nothing relating to dogs. It was really relating to transfer of data. Basically, they were addressing the transfer to Google and the transfer to Facebook. And just to give you a little bit of insight of the kind of answer that we received from the controllers that we contacted, especially telling them, guys, you are transferring data to the US, do you know you need SCC or transfer tool and everything? A lot of them didn't know a clue of what we were talking about. They really didn't know what we were talking about. What is a transfer? Or I think it's just a mistake. We don't really know what you are trying to target here. Some controllers just replied that they were using the SCC, the new SCC of the Commission in last November of last year. So it was interesting to see that they were already using SCC that were not even approved. Some companies were relying on the safe harbor, which is really interesting since it has been annulled 5 years before. Some companies just contested that they were even transferring personal data, but also mentioned that they were using the SCC. So it was interesting to see companies using an umbrella when there was no rain outside. So basically, you use SCC, but we don't transfer personal data, trying to figure out what they wanted to do with the SCC then. So it's all these answers that we receive as a first insight from the controllers. And we also have a complaint against the European Parliament when the European Parliament mentioned that, yes, maybe some data were transferred. We're not really sure. But if some data were transferred, and we are not sure again, they might not be personal data, but we're not quite sure. And anyway, we use SCC. So you see, even the European Parliament is not really sure about which data are sent to the US, under which contractual clauses. It's not really clear for everyone. And we have also other controllers basically referring us to the model clauses of the SCCs on the website of the Commission. So it's also interesting to see, guys, can you please give us a copy of the SCC that you signed with Google or Facebook? And these controllers basically refer you to the model clause of the Commission on the website of the Commission. So not the signed one, not the one with the fulfilled elements on the annexes, just the template which is available on the Commission website. So you can see there is still a lot of misunderstanding and a lot of work to do after the Schrems 1 and Schrems 2 decision on the side of these companies, not always, of course, SMEs and sometimes largest company, which are not always have the knowledge of level than Microsoft, of course, and Facebook. We are obviously totally aware of the problematic and the issue at stake. But you could see that the answer that we receive are also quite concerning for us, because we can see that nobody really have a clue of what is happening there. And the legal analysis and the understanding of what is a transfer is also problematic in this respect. When it comes to, I don't know if we can discuss it now, but the new SCCs and EDPB, of course, is a super difficult exercise. I wouldn't like to be in the shoes of, and maybe you know that I was also working for the EDPS, EDPB before, to the shoes of my ex-colleagues drafting the EDPB guidelines. It must be a nightmare to try to put flesh on the bones of the Court of Justice, because let's be realistic, the Court of Justice did not give that much hint in the decision. They just mentioned additional measures. And I think it's more than magic that EDPB came with such a long document to try to put flesh of what could be additional measures, but it's really difficult to figure out what was meant by the Court of Justice. But again, when you read EDPB guidelines, which are really complicated, I must say that it's really complicated. And in this respect, I'm just afraid that as a privacy expert, you might not learn a lot, but as a non-privacy expert, you might get lost. So I have some doubts about, the added value of such a document. Is it really helpful for the data protection expert? I hope so. But for the guys who never read any document on this type and on this subject matter, it might be even more confusing for them. And as I told you, you could see that the companies were already confused before. So I don't know how it's going to work out for them, but of course they will of course just make a living for the law firms, that's for sure. But I think it's not the objective of the SCCs and the EDPB guidelines, of course. What you can see in the EDPB guidelines as well is this inclusion of, as you already mentioned, in the law and the practice of a third country accessing the data. Not only you have to go to see into the law of the third country, but you also have to go into the practice of this country. And there, I might disagree with Laurent when you say that you should be maybe looking at how the legislation in the third country might be put into practice. But I'm not sure that's what I read in the EDPB guidelines. They say you have to look at the law and the practice. Because if the law is not applied, then we have a problem with the essential guarantees document of the EDPB. EDPB also adopted an essential guarantees guidelines with 4 main conditions for the legislation of a country. And if the legislation of a country is not clear or transparent, therefore, according to the EDPB and also the Court of Justice and the Court of Human Rights, this legislation is not up to the standard of the EU. So you should not even go further and to see whether this legislation is applied in practice. If there is a possibility for a national security agency to access the data under the terms of a law which is too broad according to the standard of the EU, I think the analysis should stop here. If the possibility exists, you should not go further and see whether this legislative possibility is put into practice in reality. But there for sure, I can refer to the submission that NYOB published on our website about the SCC and the EDPB guidelines. but I think it's also interesting to see this interaction between legislation and practice, because, you know, there was this whole debate about the so-called risk-based approach when it comes to transfer, but I think this discussion should be ended. There is no risk-based approach when it comes to transfer. That is not in the GDPR, that is not in the recitals, there is nowhere to be found in the GDPR. This risk-based approach is not to be applied in a data transfer. Either the data are transferred to the US under a transfer clause, either they are not. The law is quite clear. Either you can transfer the data, either you can't not. Sorry, you can't. It's quite late here. I'm so a little bit tired. And maybe a last point. I understand that the assessment of the law of other countries will be a very difficult exercise. I also feel for the law firms and the companies having to assess this kind of third countries, because I think the exercise is even impossible. Let's face it. How is it possible to assess the legislation of all the third countries when you want to transfer the data? I guess even for Microsoft, you might confirm it, Cornelia, it must be super difficult. So can you imagine for other countries, it must be impossible, I would say. One little concern that I have in this respect, and of course I'm speaking on the side of a consumer organization, I could regret that in the SCC, the new SCCs, the assessment that has to be made by the exporter and the importer doesn't have to be shared with the data subject. And as you know, we would love really to focus on the enforcement. And how do you want the data subject to enforce his right if it's not even aware or not even entitled to access the assessment that was made by the exporter and the importer of the third party, the third country legislation? I think that might be problematic. In my memory, as far as I remember, the assessment that has to be made by the exporter and the importer has to be produced and shared with the DPA on request. So it's not even an automatic process to share with the DPA the assessment that you made about the third country legislation. The DPA can ask to share this information, but the data subject, the individual, the one whose data are just transferred to the third country, is not allowed to see how this evaluation has been made. And I think that's really a little bit of a problem for me when the individuals want to understand what is made with the data. Because what will be the answer of this person? It will just ask the exporter and the importer, have you made an assessment of the legislation? And the answer will be, of course, don't worry. And that will stop here. And for me, that's a little bit of a problem of the new SCCs. That's the first thought that I wanted to share.
Thank you, Romain. I always imagined that having someone from NYOB would be non-controversial, and I was right. There was nothing controversial about what you said. You raised a lot of issues. Struggling to know where to begin. One of the things that a lot of people say is that the current situation is fluid. It's in a state of flux, and if it is, how is that going to change? You said that you wish to avoid, everyone wants to avoid Schrems 3, based on the assumption that the two fundamentals of judicial redress and massive collection of data are not being adequately addressed by the privacy shield, and you suspect they're not going to be dealt with in the current negotiations between Brussels and the United States. You also mention third countries besides the United States, which opens up a whole bag of questions. We've mostly focused on the United States because the Schrems judgments were focused on US-based organizations, but there are a whole lot of countries out there besides the United States. And as you said, tackling the law and practice in each one of those will be a major challenge for multinationals, multinational companies and multinational law firms. You also talked about, and I wanted to get onto that, data subjects. Where do they fit into all of this? One of the notes that I made earlier on was how many people actually care. And I think a lot of people don't care, but those who do care don't get much of an opportunity to engage in the process. There are numerous issues associated with the statement that I just made. So I guess this is a good opportunity to open up the discussion. Are the steps taken by the Commission based on the guidelines of the produced by the EDPB, which Roman described as a nightmare to write? When I read them, I thought they could be a reasonable cure for insomnia, but that's just me. Sorry, one has to inject a little bit of humor into this. Yeah, where are we going with this? Is this going to work, or is there still, have we just scratched the surface of a problem that, which, as Wojciech said right at the beginning, the DPAs were not brave enough to tackle earlier on, and it took Max Schramm's initiative and guts to follow it through twice. What are the chances that we are going to, and also, you know, coming back to this thing about the guidelines, they are complicated. There is a lot of work for big companies and their lawyers. And there are a lot of SMEs that are working in data transfers that will not have access to the kind of facilities that Microsoft have and some of Laurent's clients undoubtedly have. So where are we going with this? How is this going to pan out over the coming months and years? Do we need to do more? Because it feels like there is a situation that we've created that is a behemoth, and there's additional levels of complications. There's goodwill, but a lot of complexity, and still a number of things which are not being dealt with. So where do we go to next? So who would like to respond to that, or respond to anything that has been said by any of the speakers? Yes, Wojciech, please.
So if you have, if you think that there is too less controversy at the moment, then let me then ask you a little bit provocative. Was it what you said about the cross-border transfer or about the climate change? Because actually, we can put the same questions as far as the climate change is concerned. Who cares? Where are we going to? Isn't it too complicated? How do you want to count how the ships and the vessels, what is their impact on the distribution of carbon dioxide? How to solve the situation of those who decided not to deal with the waste in the way that we expect? Where are we heading? Are we heading to catastrophe? Yes, probably yes. And this is also these are the questions which we are asking right now about the data transfers and about the way how we will have the control over the data. And I'm sure that these documents are hard to read. I'm sure that they are not giving the answers. But unfortunately, I'm not too optimistic, because what I can see right now is a kind of deadlock in which we are really heading to the political agreement between the United States and Europe, which will not change too much as far as the merit of the decision of the Court of Justice is concerned. And we will have Privacy Shield 2.0, which will lead to Schrems 3.0, and Some of the politicians simply are of the opinion that it will not happen during their term. And that seems to be very unpleasant answer to the problems that we have at the moment, and a little bit like pushing the decision to the next generation, as we also do with the climate change.
Wow, yes, climate change. That's really brightened up my evening completely. That glass of wine can't come soon enough. Cornelia, yes.
Yeah, I think Wojciech is right in saying, if I interpret positively what he was saying is, well, we have a problem and we need to address it and solve it. And both the recommendations of the European Data Protection Board as well as the standard contractual clauses will have to have, just as the law itself, even so this is guidance in the one hand and a decision on the other, it requires work by the lawyers, work by the companies to understand and interpret what is meant in order to be able to implement this into compliance processes that are existing. So that is a lot of work. And in this context, there will be question marks around certain issues. So this is why at the very beginning, I stated that we welcome the process that the Commission is now starting to put in place with frequently asked questions or document, a living document, and if I understand it correctly, a process of continuous feedback and dialogue with stakeholders that will be helpful in creating a broader common understanding in what these standards, if I may say so, look like. It's also helpful that the Commission is working towards certifications, code of conduct in the context of international data transfers. And maybe in this context, it's worthwhile to note that just recently, the European Data Protection Board gave a positive opinion on a cloud code of conduct. Actually to two, the one that has now been approved by the Belgium Data Protection Authority, has a module on international data transfers as well. So you can see that companies are very eager to find ways to provide the necessary assurances in order to continue business. It is true that size matters here. The resources that bigger companies can dedicate to that is obviously not comparable to smaller or even micro businesses that very well might be transferring data as well. Being a micro business doesn't mean that you're not having international data transfers, in particular in the digital world. So we probably need to find mechanisms for these SMEs, and I think the associations here will probably have to play a significant role in helping them to understand what is necessary and what has to be done. But then there will be also, and I have no doubt about it, there will be also interpretations that will have to be decided in court at one point. And one issue that Laurent mentioned is certainly the legal uncertainty around recital 7, what that actually means in the context of data transfers to a importer that is subject to GDPR, and whether the scope of Article 3 prevails or Article 48. And that at least to my understanding, there is no jurisprudence on these issue. So there will be interpretation necessary through decisions as we go. But at the same time, I believe that I'm not talking necessarily about a Schrems 3, right? But I'm talking about also accepting that jurisprudence has also always been part of the development of law, and so I wouldn't just discard it as a catastrophe when that happens. I want to say that. So we can of course be very pessimistic, but at least in recent weeks or so, I thought that there are positive signs from which we can work from, and of course, that requires time, and in particular, it requires dialogue within the stakeholders to have common understanding.
Yes, Laurent, please.
Yes, I cannot agree more with what Cornelia just said. I think, whether it's for data transfer in particular or more generally for GDPR, it's a work in progress. It's always a work in progress. I mean, even when you look at the recommendation, they're asked to assess regularly. Why? Because you have to assess regularly the evolution of the case law, the evolution of the enforcement practice of the DPAs, and so it's the evolution of data transfer, obviously. So it is always a work in progress. I think we have to welcome the recommendation because and the new SECs because they help. I agree with Cornelia again that something probably needs to be done for smaller undertakings, which may nevertheless be global, but may have, for example, data which are not crucial, or which may transfer a lot of data but still remain small. So indeed, code of conducts and so on are necessary, I think, also. And don't forget that, I mean, the recommendations, they are useful, but they remain recommendation. There is a tendency in data protection to regulate via soft law. That remains, that remains soft law. So it's not hard law, and it's still subject to interpretation and contrary views of the courts. So those are useful tools, but they're not necessarily the final say on a series of questions.
Okay, so to use Wojciech's analogy, it's a work in progress, just as tackling climate change is. We may all be doomed and can do nothing, but we are doing the best we can, and it's going to take some time to address all of the issues. One of the questions that came
But let's be sure that we have enough time.
Yes. Are you talking about climate change or data transfers now? Both. Right. Well, that's something we all agree on. Absolutely. One of the questions was, has Schrems 2 impacted any of the data transfers between member states within the European Union? We've mostly been talking about between the European Union and the United States. Is there anything there for between member states? No? Yes, Roman.
It's not just to jump on the other reaction, if I still may, because you said it was not provocative and controversial enough. So I'm happy to give my 2 cents because I kind of like to provoke a little bit. I
apologize, Roman. I'm British, and that was irony.
It's perfect, and I'm Belgian, and I practice even more.
Okay.
Sarcasm is my second nature. No, I'm happy to hear that we saw developments after the Schrems 1 and Schrems 2 decision, but I'm just wondering in the favor of which individuals and companies are the development to be seen. And Cornelia, I agree that Microsoft made a statement after the Schrems 2 decision, but I'm maybe sure that you know what I'm going to. I also read this statement from Microsoft, and I was quite surprised to see that Microsoft want to exclude any collective redress and class action against Microsoft from this new statement. And I was not sure I was going in the right direction for the individuals to have the enforcement of their rights. And I was not sure why this decision from Microsoft to exclude any collective redress or class action against Microsoft from organization from NYOB, for example, was the intention. And of course, as you say, and I totally agree with Wojciech, nobody care. That's what I think NYOB exists as well. We care, but if even NYOB, the ones who care, cannot act, then I'm not sure that we are not discussing in the void here. You know what I mean? Because enforcement will have to come from somewhere. And as you said, so far, and since 2015, we haven't seen one single decision from a DPA banning a transfer, except one from Portugal. So only one decision in 5 years. So if you ask me whether I have good hope about the enforcement of the GDPR and the Schrems 2, the answer is already in the question. No, I'm not sure it's going to go better. I had a second provocative element to bring, maybe, is all this assessment of third country legislation. It has to be sometimes based on the transparency report of the companies. And again, it's nothing against you, of course, Cornelia, but I've been through this transparency report. And of course, you're not the other one. Facebook is doing that and everything. And you know that the 1 billion question in the room is usually, and we had it with the French debate about, is this Amazon service or Microsoft based in France or in the EU still subject to FISA? That was the problem. You know, whether this US company based in the EU were still subject to mass surveillance in the US. And this question was debated before the Conseil d'État in France, supported by the CNIL saying that, no, we have a problem with these companies based in the EU. They are still subject to the FISA. The answer, I don't even know it myself, to be honest. But then it would be nice to see in this transparency report from which government agencies a request is coming, but also to which entities of these groups the request is addressed, because that I can't see in the transparency report. It's we see, for example, a lot of time Facebook, happy to see that, oh no, it's not Facebook LLC, it's Facebook Ireland. You have to request Facebook Ireland or Facebook France when you have an access request and everything. But when it comes to transparency, the transparency report of this company is not really transparent to me, because when you read them, you just see, oh, we received a request as Microsoft, as Facebook, as Google, but you don't know, you know which government agency made this request, but you don't know to whom this request was addressed. And that would help the citizen to know whether, for example, a request from the NSA or from an American agency addressed to Microsoft France is answered by Microsoft in this respect. And maybe I read it wrong, Cornelia, but and you're totally not the only one, because these transparency reports are usually uniform, you know, they have the same format and everything. But I was struggling to find the answer to this question. Who received the request? Who is Microsoft? That's a question. Who is Microsoft? Who is Facebook? Is it Facebook Ireland, Facebook China? Who is receiving this request from which government? And that might be an interesting, I think, transparency exercise to address the recommendation of the EDPB guideline, to be even more transparent. I think that is not impossible. And a third provocative remark, because a third one is also the last one. I understand that code of conduct, it may be a matter of hope and everything, and especially the one approved by the Belgian DPA. But I just learned today that the monitoring body of the code of conduct of the approved by the Belgian DPA was founded by Microsoft and Google. So maybe Cornelia, you have some other information about it, but I cannot trust this, if this information is correct, but I cannot trust a monitoring body of a code of conduct monitoring the cloud services provided by some big companies who are funding the monitoring body of this code of conduct. So I agree that code of conduct is a nice way out, especially for transfer, but of course we have to restore trust and not to destroy trust when it comes to monitoring bodies, of course. So again, it's a progress, of course, for companies and for transfer as well, but you also have to see the progress for individuals, more transparency, how to enforce your rights, and how to access the information. And of course, I was provocative on purpose because you were there, Cornelia, because I'm happy to, well, because I don't know the answer, of course, so I just take the opportunity you hear.
David, can I just respond to a couple of the things? There were a lot of stuff now, and I think we're already over time, but Roma, a couple of things. So on scope, just to be clear. So yes, indeed, the mother organization of scope Microsoft in Germany was a founding member. We left that for many years, and we're not involved at all in when Scope was created in Belgium. And in fact, to be fair, we joined the efforts around on the Scope Cloud of Conduct fairly late. So there were a lot of other companies that have been doing a lot of the hard work in creating that. And we just to give you, Romain, a bit of a context, you're absolutely right. SRIW many years ago was founded, but we left it for many years and just recently joined again for very different reasons than the ones it was created at the time. So I think that should not sort of count against Scope, which is a really brilliant organizations, and they take the auditing and the assessment of the adherence to the code very serious. And it took us almost until the very end that we could adhere to the code of conduct with Azure. So, of course, in codes of conducts, supervisory bodies are usually funded by the members that create the code of conduct. That's part of how codes of conduct work. So I think that is maybe a little bit more trust on your side is necessary in this context. I forgot a lot of the other things that you said. I think and maybe one thing, yes, there is I think you actually don't, I'm not sure whether you mean FISA or whether you mean the Cloud Act in the context of even where you have companies deciding to have data located within the European Union. And we have recently announced the EU data boundary commitments, where we will, over the next month until I think it's end of next year, commit to do more of that, including with a newly created Excellence Center of Engineering to help our customers in this context as well. And that is a decision that relates really to the fact that there is a tendency of customers requiring data localization, which I still believe is not necessarily relevant in the Schrems discussion. The Cloud Act is also something that any company in Europe that has significant business in the United States might be subject to, and it requires, again, as with the EU-US Privacy Shield negotiations, a commitment from the states to work on the EU-US law enforcement agreement, which is on the table currently, unfortunately, on sort of not moving forward quickly because of the e-evidence proposal. So there's a lot of connections that relate to each other, and that goes a little bit to the point that Laurent mentioned with the data retention decisions that you have to read in context, and they did look slightly different than eventually the very strict interpretation in Schrems 2. And I will just say, when you look at European member states, and that's maybe in return to be a little bit provocative, is there are many member states in Europe, and you can look at the telecommunication transparency reports. Telecommunication companies in Europe have joined the GNI commitments and hence publish these transparency reports too. But in many countries they can't because it's prohibited by law. So there's a bit of that too. And so we have been in the United States as Microsoft fought in court to be able to provide more transparency, and just recently again did so, and also testified in the Judiciary Committee to continuously improve. So our commitment to improve transparency absolutely is there and will continue to be there.
Excellent. Do we have any questions from the audience? We've overrun somewhat, but it seems churlish to stop when we're in full flow. If there are no questions from the audience, we've talked about the United States an awful lot. Are there concerns about other countries such as China or Russia? And is anything being done to work with the governments as we are doing with the United States? Wojciech, I guess that's a question for you.
I always have a problem to discuss about this because I remind myself how the map of Europe looks like. Just move your sight to the east a little bit and find out that there are the EU countries like Finland, Poland, Romania, Estonia, Latvia, and Lithuania, who have the just next door neighbors who are the third countries. But you have to remember also that the countries like Serbia are also the third countries. So for many people in Europe, the transfers of the data to the third countries is not the internet-based problem. It's not the problem which is of the big tech. This is an everyday contact with the people who are just over the border and whom you have to cooperate with. I remember the times when we were organizing the European Championship in football in 2012 together with Ukraine. And you should see the face of the people from UEFA when they got to know that Ukraine is the third country. And each and every disclosure of the data of the people who are going to get into the stadium in the event which is organized together by the EU country and the third country would be the transfer of the data to the third country that is that these tools have to be used for. So yes, of course, we think about US, we think about UK sometimes, but in fact we are talking about all the countries around the world. And for many of the EU member states, the transfers to Russia actually or to Belarus are much more everyday basis thing than the transfers to China even.
Yeah, absolutely. Cornelia, are you still with us?
No, Cornelia said that because of the family obligations she had to leave. Oh. Unfortunately, it's the same with me.
Right. Okay. So Romain, you wanted to say something, but we should wrap up. So
No. I was just waving at Cornelia leaving.
Okay. I thought you were trying to attract attention.
No.
We should wrap up. We have gone over time. So could we wrap up the conversation? Could we have some final words? Just a few words, Laurent, from you, and then Romain, and then if you could close us, Wojciech, that'd be much appreciated. So Laurent, any final thoughts? And of course, keep it reasonably brief.
I mean, I think it was a very interesting discussion. I think there's a lot of work ahead of us because we didn't discuss the timing for the implementation of new SCCs, but you know that we can still use the old SCCs for 3 months, but then afterwards we have to use the new ones. The old SCCs have valid for all data transfer until December 2022, but there's still a lot of work for ahead of us, especially during the summer break, to make sure that all companies. So it's I said it's work in progress, but it's really for a lot of companies. It's a lot of work in the 3 months and then certainly in the year to come.
Thank you. Undoubtedly, Romain, any thoughts you'd like to leave us with?
Yes, as I say, of course, at NYOB we are a little bit obsessed with enforcement, and it's one of the reasons why I just decided to join NYOB, because I would love to see enforcement of data protection. And since it seems to be complicated to have enforcement on the side of the DPA, and especially as you see the Max Schrems 1 and 2 saga with the DPC, which is going on for like almost 9 years. I'm wondering whether we will not, according to our plan, go directly to the judge to try to enforce transfer enforcement instead of going to DPAs. It might be a little bit more effective to ask to a judiciary to take a decision on the transfer mechanism instead of going to very complex procedure and one-stop shop procedure to trying to enforce the transfer mechanism. So we see whether we have better chances.
Okay, that's an interesting thought. To leave us with Wojciech, could you
Yes, so a little bit optimism in the end. I'm very happy that this debate today was organized by Trust in Digital Life together with Cybersecurity for Europe. And my special thanks for Cybersecurity for Europe, because that is really long-term thinking when you are including the discussion about the transfer to the third countries into the general problem of cybersecurity, because the personal data protection is not the discipline of law itself. It's not discipline of the lifetime. That's one of the tools that we use in order to protect the human dignity and to create a just world. And I guess in few years, in several years, that will be the part of the bigger picture, which is the cybersecurity, which is called cybersecurity now. And the number of projects which are included in cybersecurity for Europe are creating this new way of thinking about the security in the digital environment, which the data protection is a part of. So I'm very happy to be here. I'm very happy to talk with all of you. And I hope that we'll have more opportunities like that. And I hope that we'll be able also to talk with Romeo, whom I of course remember from EDPS office, and with Cornelia, who theoretically works just over the street from the EDPS office, and whom both of you I haven't seen for more than a year and a half.
Well, we've been very happy to have you and the other panelists join us, and thank you for your kind words about TDL and CyberSec for Europe. Security and privacy are not the same thing, obviously, but they are bedfellows, they are cousins, and so much of the work that we do in the CyberSec for Europe project is privacy related for all the reasons that you just mentioned. So, and we very much look forward to seeing all of you again. It would be very nice to be in Rue Montoyer, but who knows when that's going to happen. Yeah. So thank you, and thank you for everyone for staying with us. There is still just over an hour before the semi-final starts, and what can I say? Thank you. A fascinating discussion. I think we just scratched the surface of the many issues and complications and intricacies associated with data protection and the implications and the consequences of Schrems 2. And maybe we can revisit it again in a year's time and see how we progressed. That would be a very fascinating thing to do. So thank you to Cornelia, who's left, and Laurent, to Romain, and to Wojciech. And I wish you all a very good evening, and I look forward to seeing you again in the future. Thank you.
Thank you very much. Bye-bye.
Bye-bye.
You are currently the only person in this conference.